boy Quilly Philly in the building. You know what I mean? Uptown in the building. That's how we carrying it. Right here on Hot 97 with Funk Flex. You already know.
You know what it is. Quilly.
Oh, man.
What part of Philly?
We uptown, man. Haines Street. We're from the projects, man.
Be
You know
clear?
what I mean? Yeah, just to get it clear. You know what I mean? We from uptown, man.
Let's do it.
It's a pleasure to be here. Fresh out the jail cell, too.
Let it be known.
You know what I mean? Come right, fuck Flex up real quick. You know what I mean? That's how we carrying it, man. That's ball. Yeah. If I ruled the world, I'd lower the coke prices, raise the welfare, and lower the perk prices. You could pay for a feature, even though the flow priceless.
What's up? What it do? What it should be? It's the good be. Hopefully, what it should be. It's your boy Skinny Suge. It's the Vent Online Podcast. The god of this shit. You dig me? I want to get right into it because about time you view this video, you will understand that we are a day late. We're speaking about day 9 of the ARAB federal racketeering trial. For those of you who are just tuning in, catching up, Philly rapper ARAB was indicted along with 8 other defendants October of last year on federal racketeering, influence, drug trafficking charges. We are in the closing arguments. The case is finito. It's done. Bob Goldman, Robert E. Goldman, who was No Breaks Braz's attorney in this trial, Hans Gasson, he put on a show. He put on a clinic. Exactly what a closing argument should be, from the perspective of a defense attorney and a defendant. This is exactly what you wanted Bob Goldman to have done to kind of secure doubt in the mind of jurors whom hold your fate in their hand. So if you notice, our platform is going to be presented a little differently than prior to, because we bumped into some folks who kind of believe in what we do and feel we have the necessary tools to secure the bag. So they're going to put some resources and some energy and time into what we do, and hopefully those changes will be improvements that you like. But before we even get into that, what's her name? Marissa Osario. Shout out to Marissa Osario. She sent me this edible arrangements mug. I have one. Had one. I broke mine. Just dope that she sent me another one. She watches. She subscribes. Appreciate that. I won't put your social media handle out there because in the email you asked that I not do. So I won't do that. But I fuck with you the long way for this one. And this particular episode of the Vent Online Podcast is brought to you by A Source of Goodness Tea. Some friends of mine, shout out to Modesty Corner. It's definitely a whole vibe. I'm sipping on Black Russian right here, and this is a whole vibe. I'm digging the smell, the aroma, the taste, the natural properties. You can immediately get a sense. But let's get right into it, right? Because we had some there was some collision between our sourcing policies and YouTube's viewership policy, and we are not going to be able to Skype in an interview that I wanted to bring you from some good folks of mine. I do have some very close sources on the prosecutorial side, some folks that work in AUSA Jennifer Jordan's office, and for those of you who do not know, and I'm assuming most of you do not know, AUSA Jennifer Jordan is the prosecutor who was tabbed to run this indictment. From the prosecutorial standpoint, at the very outset, she left the prosecutor's office, the federal prosecutor's office, for a job in the private sector. So I do have some sources in her old office, in the AUSA's office. But Bob Goldman, Robert E. Goldman, you dig what I'm saying? He just completely shredded the prosecution's case in closing arguments. And he casted more than what I would deem reasonable doubt on the supposed links required by law to convict of conspiracy. And he also dived deep into the tampering of evidence by federal prosecutors and federal agents at the base level, at the foundation level, when they secured a indictment against a particular individual who was not on trial at this very point. I will show you the photograph at a later point. He also dived into, and I'm just referring to my notes so that I'm able to bring you everything. He also shed light on the thinness of the evidence that the government pieced together and highlighting that the government's case was really based upon the testimony of what the government themselves characterized as the testimony of a murderous, snitching thug, Dantes Tad Stewart. So he just kind of shredded between Dantes Stewart's testimony. It highlighted the distinguishments, or if we want to go just be outright and say the fictitious nature of what he presented at the proffer agreement, which is the initial sit-down that he had with federal agents and the AUSA, and the testimony that he gave in open court. There were some very glaring differences between the two testimonies, and Bob Goldman shredded between those two and kind of brought the juror into the fold, because sometimes during closing arguments, lawyers have a tendency to cast out the juror and the common folk who watch by using a lot of legalese and scientific terminology. So Bob Goldman did a masterful job of explaining everything that he wanted to explain, touching every facet that he wanted to touch, but doing it in layman's terms where everyone could follow along. He shredded Dantes Stewart's character. He dived into his childhood, his juvenile incarceration record, his background as far as adult arrests are concerned. Again, like I said, he picked through the inconsistencies of his testimony with masterful skill. He explained to the jury the low expectation of truth that one can expect from an individual who is facing life in the state penal system versus one who inevitably in a federal penal system would face what would amount to numbers. He just simply did a masterful job in closing, keeping in mind that closing arguments are not what they used to be. They're shorter than they used to be, especially in the time of my federal trial, which closing arguments exceeded 2 hours on both sides. The attention span of jurors and judges are television trained, if you dig what I'm saying, right? The time allowed for a closing must be used in the presentation of the evidence, in many cases, the testimony of an expert. So it's graphics and charts, and fact finders want visuals, right? Television by other means, right? So in the amount of time that has become accustomed in this day and age, Bob Goldman, with the time that he had to work with, he did a masterful job. And again, there is very little wiggle room for Bob Goldman, but with the amount of wiggle room that was provided for him, again, he did a masterful job, and he did exactly what a defense attorney should have done in this case. And again, this also leads to more confusion as to A.R. Abb's attorney on record, Ed Meehan, exactly what his position in trial was. So I called a friend of mine who's very much a mentor of mine. He's very much elder to me, but he also represented me in many cases in my appellate cases. He is a super lawyer of great repute, well known in the community, in the law community. So I called Norris Gelman, and I asked him for his professional opinion, right? His legal opinion as to what exactly did Ed Meehan, what role did Ed Meehan play in this particular trial? Because again, as we spoke about in previous videos, his role was very minimal. He didn't do much of anything. It's really not a necessity for us to get into exactly what he did. He didn't do much of anything. So Norris said to us in no uncertain terms that he believes that Ed Meehan's position in this case was to be a fact finder and to gather information for post-conviction appeals. He believes that the defendants believe they really don't have a shot in front of a jury. He believes that had he taken a plea deal, the defendants do believe that they will be found guilty. He's saying that, but had they taken a plea deal, they would have shut the door on some things that would not have come to light, that would have provided them an open door, right? A chance for the door to remain ajar in post-conviction appeals. So they wanted to get some inconsistencies and some things out in open court. So he's saying that Ed Meehan's role in this case is specifically as a fact finder for post-conviction relief efforts. For those who may not know, there are very stark differences between the opening statement for those of you who are asking why X, Y, and Z was not said, or why X, Y, and Z was kept out of the closing arguments, or there are very stark differences between the opening statement and the closing arguments. Just a brief description of what that is. So, the opening statement at the beginning of trial is limited to stating the facts, right? So, this is each party's opportunity to set foundation by outlining for the jurors the core dispute of the case and providing them with a general, like, kind of roadmap, but using the evidence at hand. Whereas in the closing arguments, only after the jury has been allowed to hear the factual evidence in the case, you are then afforded the opportunity to remind jurors why they should side with your particular disparity in the case. And you can persuade them to adopt your interpretation of the evidence that's favorable to your position. In closing arguments, unlike in the opening statement, you are allowed to use hypothetical analogies, you are allowed to use allegory, you are allowed to use simile, you are allowed a lot of room to use hyperbole and things of that nature. But there are very stark differences in the closing arguments. You are afforded much more freedom in the closing argument than you are in the opening statement, which is why I believe they saved the closing argument for Bob Goldman. Because Bob Goldman is not only a masterful litigator, but he's a top-notch oratory expert. So, again, Bob Goldman did a masterful job shredding the evidence, opening the door for the jury to find a reasonable doubt. He cast more than, in my personal opinion, he cast more than what reasonable doubt is under the expectation of the law. And he did give the defendants a door, some breathable room to hope for anything but conviction. I want to do some more touching on Dark Low when I get a second. I'm going to do, like I said, 2 parts to this particular video, but I really wanted to get this out to you because the time limit, YouTube gives us a very small window, unless you have 1 million followers. They give you a very small window to operate. So I wanted to kind of put this out there and give my followers. I actually uploaded this video on time, and I erased it, and I'm having to upload it again. So excuse me for the delay, but I really wanted to make sure I give you in-depth and up-to-date information, and the information from as close to the situation as possible. So this is Skinny Suge, man. It's the Vent Online Podcast, and stay tuned, man. I'm coming back with part 2, man. I'm going to touch on some other things with Dark Low. I'm going to touch on some things with some of the fellas convicted in the case, and I want to touch on the possibilities and the possible outcomes either way. So stay tuned.